Sorry, we've had to start early because I need to do this quickly. I can attend some event and then probably have another session with you later in the night. So tonight we are going to, first of all, one of you, I don't know the person, the one student, the lady, she sent me a question on a Telegram. So because of that, I want to discuss that with you first before I'll discuss the other question I was going to discuss with you. So let us think through together. And that question is in relation to, I think, the constitutional law. So we'll look at that first. But just before we start discussing this question, let me remind you again that as you have like the few days to, I mean, next week Friday, if I'm not mistaken, you'll be writing at next week, the 23rd. 23rd should be probably, is it next week Thursday or Friday? But you'll be writing. So at this stage, what you should do is not to panic, but as I keep telling you, the 6 subject areas. Keep auditing yourself so that the particular subject in which maybe you have some outstanding deficit in trying to understand properly certain topics, you can seek assistance. So that is what you should do. And secondly, as I said, in terms of how to properly structure your problem-based question answer, go back to the guidelines we gave with the IRAC, that the layout and the structure of your answer will be good. And of course, you've also been discussing how to structure your essay questions. So once you pay attention to this, I think that you should be good and should be able to pass without any fear. Good. So having said that, the question the one of you asked me on Telegram, I don't know if the person who has a question is online, because I've just sent the link to you. Are you here? Okay, maybe probably he's not here yet. Okay, so the question she asks is what I've just put over there. Is the judiciary beyond critique? What is the scope of the independence of the judiciary in Ghana? Before we come to discuss this question, I think that the questioner has not made a mistake, because if you look at the media space for quite some time now, the issue of critiquing, attacking the judiciary has become a topical issue. And for that matter, if you are going to do examination of the kind that you're supposed to be doing, insofar as it falls under one of the examinable subjects, in this particular case, constitutional law or Ghana legal system, it is not out of place for you to think through such an issue. Who knows? Good. So let's assume we have this question. Is the judiciary beyond critique? What is the scope of the independence of the judiciary in Ghana? This is a pretty straightforward question, but it must also be thought through properly so that you don't miss significant points. So things are at play here. First, of course, as we have indicated, you always have to give a good introduction. But before we structure, our response to the question, let me give a little bit of just a brief background exposition. So first and foremost, the idea of judicial independence is very much linked to other important constitutional doctrines as constitutionalism, rule of law, separation of powers, and of course, judicial review. And first and foremost, the idea of having a written constitution reinforces the idea or the resolve on the people of the framers' constitution to have a limited government. That is, to have a constitutional regime underpinned by constitutionalism, have a limited government. So if you are going to have a constitutional dispensation in which you have restraints on those who wield powers of governance, then it is important for us to also have some distinction in terms of functions and powers. And for that matter, the idea of separation of powers will come in, where the traditional governance powers, lawmaking, implementation of law, interpretation and enforcement of law are shared between the three governmental arms or organs of governance. But then, as we know very well, that the kind of separation of powers that we practice, we don't practice what we call like the very rigid one, but a sort of like a hybrid or a flexible version of separation of powers, so that we have some interrelationship, some interdependence, between the various arms of government, despite the fact that some traditional areas you still have that that kind of like the strict separation. And for that matter, if you have a limited government, if you have a constitution which is also premised upon a written constitution, as Chief Justice Marshall said in Marbury and Madison, then there's that presupposition that it will be responsibility of one of the organs of government to actually ensure that all other organs, all other agencies stay within the strict parameters of that which the Constitution has conferred on them. And if that is the case, then the most suitable organ to do that is the judiciary, the courts. So therefore, if the court is going to be able to actually play a function of making pronouncement on constitutionality in terms of the actions or commissions of the various organs of government, then it must enjoy independence. It must enjoy independence in terms of carrying out its function, in terms of its finances, in terms of security of tenure and all that. And more so, if we look at our own country, Ghana, we are very much aware of of course, the unfortunate decision in Ray Akoto and 7 others. We are very much aware of the no court done broadcast by the Prime Minister, Busia. And then we are also very much aware of the murder of the 3 High Court judges in the cool blood and then 1 soldier and all that. So all these things serve as a very important background in reminding us that the independence of the judiciary is a sine qua non for ensuring that the supremacy of the Constitution, which is enshrined in Article 1 and Article 2 of the Constitution, would actually be meaningful. Because if you do not have a judiciary which is independent, then if you have a constitutional provision as you have in Article 1, that the Constitution shall be the supreme law of the land, and that anybody at all, Article 2, can go to Supreme Court and seek a declaration that something is in contravention or inconsistent with the Constitution and all that. All those things will be meaningless if you do not have a judiciary, which is, if you like, independent and will be able to play this particular role. So I'm saying all this, not in any structured function, but just to give you a very good appreciation of what is at stake. But the other thing we should also remember is that if you look at all the arms of government, the executive, the legislature, they are all subject to direct democratic accountability in the sense that they are elected, and where the electorates or the governed are not satisfied with what they are doing, do not be returned to office should they go and seek re-election. So we have that kind of, if you like, that kind of inbuilt checks within the democratic process as far as the executive and the legislature are concerned. But for the judiciary, by and large, especially the type of judiciary that we have in our jurisdiction and most common law jurisdiction, we don't vote on judges. You don't vote on judges, especially so, maybe like the Supreme Court, which is like a policy court and all that. For that matter, if they give decisions or interpretation which people do not agree, should there be an open criticism of their decision, of their opinions, and so on and so forth? Or will a very robust open criticism also actually undermine the confidence of the judiciary to be able to do their work and all that? So these are the general ideas which we should actually have at the back of our mind. So in the light of this general opening statement, let's get back to the question together. Is the judiciary beyond critique? What is the scope of the independence of the judiciary in Ghana? So if you have a question like this, how do you plan our answer? Introduction, what is supposed to be done in the, like, what are some of the ideas? You want to speak, just unmute yourself and then you speak. One person at a time. We are doing sort like an answer plan. Yes. Be together. Are we together?
Yes, sir, we are together.
Yes, please, we are together.
Okay, so we are trying to put our thoughts together to see what points, for example, should go into answering a question like this. Yes, Jay, go ahead. Jay, go ahead. You can mute yourself, please.
Hello, good evening, Doug.
Good evening.
So in the introduction, I'm going to attempt it this way, like talk about the judiciary being part of the arm of government and talk about the power the judiciary has.
Okay.
That's what I'm going to talk about.
So being one arm of government. Okay. Are you done? Jay, are you done?
And yeah, yes, sir. For now, I'll come back.
All right. Any other?
Yes, sir. Thank you, Doc.
Yes.
May I speak?
Yes.
Okay. Yes, if I should attempt this question, I will start by introducing, as you said.
I'm teaching online.
But my introduction will contain the judiciary being an arm of government.
Okay.
And their independence is actually contained in Article 125.
Okay.
After I have done that,
Independence 127.
127, thank you, sir. Then what I will follow next as the body is that the Constitution is the supreme law, and therefore everybody's action and inaction is supposed to be submitted and be guided by the provisions of the Constitution. In Article 1, and then Article 2, where everybody who has some allegations against somebody with regards to a person's conduct, which is in contravention with an article or a provision in the Constitution, is open for criticism. Then from there, I will also touch a little bit on the freedom of speech by all citizens. And when I'm done with this one, I don't know whether to conclude now because I just thought of it briefly, but how I will now conclude it will be that since the judiciary is the one that is supposed to provide or to serve as referee when there's litigation, and everybody is entitled to seek redress from the judiciary, even though we can criticize them, we must criticize them with some amount of caution, because it mustn't be done in such a way that their integrity will be dragged into the mud where people will look at them with certain spectacles that might not augur well for the democracy of our country. This is how I will attempt it.
Okay. Okay. I mean, that's not bad. That's not bad. Yeah. So in terms of the ideas, assume, of course, there's I mean, a student who put this question together, but assuming this is what you have. So as you rightly said, the introduction, you let us understand when we say independence of the judiciary, what does it mean? And you have to link that with the idea of all the things that I have said, the relationship between limited government, constitutional government, and also the separation of powers, and the fact that you need to give the power to actually determine whether other organs of government or whether the tenets of the Constitution, for example, are being adhered to or not. And that has to be done by the judiciary. And that is why if we go to Article 125 of the Constitution, we are told the location of judicial power. We are told that justice emanates from what? The people of Ghana, and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. So this is very important. And as I said, that if you understand this very well, you have to put it within the context of even the supremacy of the Constitution as well. But if we take Article 1 and Article 2, the Constitution is supreme. And if anybody thinks that anything is in contravention of the Constitution, or that if somebody or an entity is supposed to have the power to be like the referee and say that this is an agreement with the Constitution, that is not an agreement with the Constitution, then that referee, being the judiciary, should actually have assurance of what? Independence. So that where the executive, for example, have offended the letter and spirit of the Constitution, the judiciary will be able to do that. Where the legislature has done that, the judiciary will be able to do that. Where the liberties of the citizens are infringed by anybody, the judiciary will be able to actually assert and also uphold that. And so you have to put all these in in context. And then you need to make the point that you are going to address the issue of what independent or independence of judicial really mean as a substantive point. I'm alluding to discussion of Article 127. So that would be like a point on its own. And then when we are done with that, the next one we are going to do is to address the question that in recent times, and going back to the Muntie, remember the Muntie 3 case, where decisions of the courts are subjected to all manner of public discussion. So this has brought up the issue as whether the judiciary is beyond critique. And on that, you are going to put it in proper perspective that, we started answering the question, but we'll go and we'll go by it like step by step. So the perspective you are going to put that is that it is one thing to criticize the work of the judiciary, right? The work of the judiciary as in like the decisions of the courts. And another thing to go beyond the decisions of the court to attack the persons that constitute the judiciary, that, so to speak. The latter is not really consistent with a culture which sustains proper constitutional democracy, but where you are critiquing the decision, you are critiquing the pronouncements of the judiciary, then that one it is in order. And that is why the gentleman who made the point, I could not agree more with him than that he also went to the freedom of what? Expression. Freedom of expression, of course, also include your ability to criticize court decisions and court opinions. But you don't have to go beyond the decision and opinion to attack the human beings behind it. Because don't forget, if the human beings behind the decisions, for example, need to be attacked, there's a mechanism for that. And that mechanism is the natural justice principle. Audio terram partem, as you remember, and nemo vidas in casa or sua. And that is why when there's an ongoing judicial proceedings, a party could request a judge to recuse himself, that is to take himself out of, to set aside from being part of the panel or from sitting on the case for demonstrated reason, as we know. So that mechanism, the natural justice and also the possibility of a judge recusing himself either so motu or at the instance of like a party is enough to check, if you like, the personnel behind the judicial decisions. And that is why it is not in good taste for you to go outside that and to take the individual judges, in their personal, life or capacity, and then you attack them privately or publicly in the media space, because that is taken care of by the natural justice mechanism that I have told you. But then when it comes to the decisions, as for the decisions, the opinion, so long as they are not sub judice, like they are not still pending and the court has actually pronounced upon it, and for that matter has become what we call like a frontis official and all that, it is a public, a public matter. Anybody at all can critique it. Anybody at all can, say anything that they want to say. Yeah, so let us keep that in mind. But coming back to the substantive issue of judicial independence, of course, is something that elementary you've done not too long ago, your constitutional law class. But please, in the light of the question that the student has brought up, I will suggest that you look at Article 127 of the Constitution again, so that the proper scope of the independence of the judiciary will be appreciated, because there are various dimensions of the independence of the judiciary. But before I continue, I've seen that Mahmoud hand is up. Mahmoud, yeah, let's hear you.
Dr. Dr. Good evening.
Good evening.
I've been listening to your exposition on the question, and especially with regards to the second part about critiquing the judiciary. I wanted to contribute that in answering such a question, you would have to first determine what critiquing decision, which has already set forth in the Constitution, including the appellate system and the judicial review, as you mentioned earlier. Does critiquing mean questioning the conduct of members of the judiciary, as you rightly said, and under which circumstance?
Okay, we see like Mahmoud.
Like the person question the conduct itself. I think that are the things that yes, sir.
Yeah, so Mahmoud, I think the critiquing here will certainly not be in relation to appealing the decision of the court or subjecting the court to judicial review. The critiquing here certainly will mean as whether people can comment or evaluate the judiciary, and that is why we are saying that that one has to be put in a proper perspective. That if you are going to comment or evaluate the decisions of the courts, that one is inconsistent with your freedom of opinion, freedom of expression, and all that, and the media freedom as well. And again, if, for example, you are doing academic research, and even as an institution, you want to critique the institution and not the human beings. You see that the critique here, oftentimes what happens is like it's like the personalization. It's like some sort of like the argumentum ad hominem. Like, for example, somebody will mention a particular judge and say that this judge has done X, Y, Z. Now, that kind of attack is what is not proper. And that is not what critiquing the judiciary actually should be. And that is why I have suggested that if you think that a particular judge or judges, for example, are involved in maybe certain questionable practices or whatever, and for that matter, you disagree with the decision or the case that they are sitting upon, there's a mechanism for dealing with that. And as you rightly pointed out, like either judicial review or even pending the case, we know like the natural justice principle where you can draw the judge's attention, and the judge will have to recuse himself, set aside from sitting upon the case. So those things are there. And that is why the critiquing here should be directed at the decision, at the ruling, the judgment. But the other point I would direct you is that if you're interested in the issue of the independence of the judiciary, again, go apart from Article 127 that we we're going to talk about the fact that we are talking about independence in respect of a number of parameters. We are talking about like in the traditional judicial function. A judge, exercising judicial power conferred under Article 125 and all that should feel confident that he'll be able to use his judicial oath, his knowledge, experience, and all that to come to a decision without being, for example, controlled or manipulated by anybody and so on. And of course, it also has to do with the administrative function, so that in terms of how judges are transferred, how judges are transferred, and even how judges are promoted and all that. All those things are matters which also relate to the independence of the judiciary. And that is why, in terms of like the financial independence, as you look at Article 127, you notice that administrative expenses of the judiciary, including allowance, gratuities, and all that, are charged on the consolidated fund. And that is to say that it is emasculated from interference or manipulation by either the executive or the or legislature for them to say that there's no money or something like that. The consolidated fund, of course, practically will never get 100% depleted, so long as Ghana remains like a sovereign state, so to speak. And with that matter, if monies are supposed to be paid to judges in terms of gratuities, administrative expenses, and all that, they are more or less secured. And all these things are a way of ensuring independence of the judiciary. Okay, so we have some ideas. Maybe I would suggest that look at the Constitutional Review Commission report again. And finally, look at the African Peer Review Mechanism report if you are interested. The African Peer Review Mechanism report is a PDF. You can just find judicial independence, then it will take you there. Just about the small portion on independence of the judiciary. And I look also at the Constitutional Review Commission. There's also something there, and I think that should be fine, assuming there is anything asking you to express some of these ideas. Good, so we leave that there and quickly go to, of course, unless someone has got another thing to say, but just before I leave, since you are law students and anytime there's a question and we have like a related, decided case, you don't have to forget about it. So talking about, for example, critiquing the judiciary and some of the problems, we are aware of a lot of them. We know the Buzier's dawn brokers, if you remember that, the Salaves Atunji. Do you remember that? The dawn brokers. Okay, if you forgot.
Yeah, doc.
Okay, good. And then again, the Muntie case. And these are some examples of some of the challenges that we have. And of course, I think that was in relation to the, one was in relation to the presidential petition sometime, and all those things are part of some illustrations that you can give. Good, so let us talk about this. Last year, we thought that there could be a question like this. There was no question. So let's look at it. It has to do like the land law. To what extent does the Land Act 2020 Act 1036 provides panacea to problems and dissatisfaction that landowners encountered during compulsory acquisition or when the state triggered the doctrine of eminent domain? So this is a very straightforward issue from the area of land law and of course also constitutional law, so to speak. So the question presupposes that we understand what the pre-Act 1036 regime on compulsory acquisition was, and what the Act 1036 regime, that is the Land Act position on compulsory acquisition also is. So therefore, if you have like a question like this, as we said, a good introduction, and then you must have your points clearly articulated, outlined, and then you take them and then you develop them. So the question is in two parts. The first part expect you to show some awareness that there were some dissatisfaction or some weaknesses or inadequacies as far as the law in relation to compulsory acquisition is concerned before we came to have Act 1036. So that is the first part of what you're supposed to think through. And then the second part is for us to demonstrate in what respect, in our considered view, has the new Land Act, for example, address the deficiencies or the inadequacies of the law in relation to compulsory acquisition. So I'm going to leave this one to you and take some thoughts. Yeah, so first, as is usually done, introduction, you tell us, explain key concept, and then you tell us the roadmap or what you are going to be doing in the question. So certainly you've seen compulsory acquisition or eminent domain, right? The same thing, the doctrine of eminent domain or compulsory acquisition. You need to explain what is it. And then after explaining what it is, you need to make the point that ever since the modern states, and for that matter, Republic of Ghana also came, it became necessary every now and again for the states to intervene in directly acquiring property belonging to private citizens for public purpose or the public interest. But how that is done has been problematic for a long time. The Constitution came in Article 20. We have some provisions, and still there were some operational challenges regarding certain aspects. And for that matter, the Land Act, which was passed in 2020, was seen as a welcoming addition, which will help address some of the problems. So in this particular essay, you are going to, first of all, explore some of the problems which were associated with the law in relation to compulsory acquisition before Act 1036 was enacted. And secondly, you proceed to discuss aspects of Act 1036 which has overcome, which has addressed some of these difficulties. So this, for example, is just an example of like introduction. Then you start your main body, the main response. So let's start the first part, the problems. What were some of the problems associated with the compulsory acquisition under the old regime? Yes. What were some of them? Anybody?
Delay in
Yes,
payment of
yes, go ahead.
compensation. Delay in payment of compensation.
Delay in payment of compensation. Okay, can you explain just in a second?
Can I try that, Doctor?
Yes.
In respect of that delay in payment of compensation, before the coming into force of Act 1036, government can annex somebody's land if they think there is a need for it, without necessarily making provision for available for money. So government can just annex your land when they do not have money or there is no the resource to pay the owner. But under the new Land Act, government can still go ahead to annex the person's land if it is deemed necessary for public interest or public use, but the government should make sure that there is enough money to pay you immediately the land is taken over.
Oh, okay. All right. Okay, so you've done both. You've talked about the problem and then you've also proposed how it has been solved. Okay, that is fine. What else?
Doc, my hand has been up.
Yes, Kojo, Martin, please go ahead.
Thank you. Yeah, Doc, I'll say that the old regime, when I say old regime, that's 36, yes. Yeah. We were relying solely on Article 20, and then there wasn't much in terms of clarity. But with the new acts, particularly from section 240 to 249, a whole criteria in terms of how the compulsory acquisition, the steps have been laid out at any point in time. And that addresses the issue as it has been enumerated earlier. For instance, if we take a case like Pobitetechu,
okay.
There were a lot of historical problems acquisition then for the current, and with this constitution, everybody felt that this is the time for me to settle it, and they were coming. So that case actually settled it, that no, we are referring to before 1993. And that settled that aspect. One other problem that I want to mention is the re-entry. How families or land which have been acquired and then for years they saw it as abandoned, or the interest of government has not shown interest, and then families and individuals will re-enter the land. And if we look at the recent, it's not a case, let's say the Sir John issue. The Sir John issue, for instance, is one of those antecedents. Anybody can make an allegation, it could be a family, and then they just re-enter before we are aware they dissipate the land. So these are some of the things that the current act seems to address. And then one of this thing is that now, there was this adverse possession. They will just enter into the government acquired land, set up whether farm, housing, estate, and then after some years they say that, we've been here over 12 years and therefore you cannot eject us. But with the current act, you dare not, because there's a provision to deal with you. It doesn't tolerate adverse possession in public land. So this is where I want to add my contribution.
Okay, all right. All right, thank you. Yes, any other? Okay, so and then someone has used the chat to say that under the old regime, an aggrieved person could only go to the High Court with respect to issues of compensation, but under the current Act 36, ADR or alternative dispute resolution has also been introduced. Oh, so are these the only things you remember as being the shortcomings? What about yes? What about the quantification of the compensation? Determine what will amount to fair compensation. Was it problem free? Were there difficulties with that? Were there difficulties with that? How to determine the appropriate quantum of compensation? Elizabeth Asantua, you want to speak? Okay, so my advice to you is that there was also the issue that nobody has talked about the Okujeto Blackline and the late Obichebilamte's case, that where the land, the state is acquired, and then the state does not use it for the stated purpose. What happens to the land? Nobody has talked about that, but decided cases, especially where the state said that it was going to use the land for, let's say, purpose 1, and that was not done, and later on it is released to maybe some other people, and they are using it for some purposes, and then the court will say that, well, so long as what is being used for can be construed as inuent to the public interest, it satisfies the requirements under Article 20, that the compulsory acquisition should be something which is in the public interest or should know to the public interest. Nobody talked about that. Remember that case? Remember the Okujeto Ablakwan and the
Obichebilamte.
Yes. So that is a part of the problem. Now you look at the Act 1036. From your reading of it, has it addressed that issue, or you have just left it as the Supreme Court resolve it? And you see, please, this is very, very straightforward. What I gather is that you've not read Act 1036, because if you read the Act 1036, at least from, if nothing at all, from section 239, right? If you, from 239 up to 267, you'll be able to provide answers to this question that I'm asking. So, for example, this issue about subsequent disposal of an acquired land.
Doc, please, the sessions again.
Section 239, okay? Section 2. I mean, if you wanted to get a fuller response, you go beyond the 2.3 now. I will advise that you start from section 237. Section 237 through to 238, 239, right up to 249. Up to 249. But
Doc, I alluded to this when I mentioned from the 240 to 249.
yes.
Except that perhaps I didn't, I couldn't explain myself.
Okay.
Thank you.
Yes, but you also been do yourself good. Although if you look at the 239, it talks about the fact that the compulsory acquisition by state shall be in accordance with procedure provided in section 240 to 249. You can even go beyond 249 because there are some issues related to the compulsory acquisition which fall outside the 249. And if you look at the for example, how do you determine the compensation? How do you determine what proper compensation you should pay and things like that? Criteria is provided in 256. And then what is fair and adequate compensation? Criteria 258 and all that. So I will suggest that from the 237, you can read up to 267. So that way, you are very certain that you have covered all the relevant provisions. Now, if you look at the new regime, for example,
Prof. As usual.
Who, Shika?
Don't worry.
Want to speak?
No, sir. I'm sorry. No, sir.
All right, no problem. Okay. Okay, so there are issues about even like the consultation. Now, if you are going to if you look at the new act, we have a requirement even for consultation, especially if you are going to do resettlement and things like that. So we have a lot of elaborate regime. I assume that at this stage, before we doing like the reading, that is why I am just using a broad brush approach without going systematic, because I assume that this is something that we've all learned by now. But since I am getting a different impression, I am tempted to walk through some of the provisions with you. Good. Okay, so in that case, I will spend a few minutes to work through some of the provisions with you. So as I said, in trying to understand the current regime on compulsory acquisition, of course, the first point is Article 20 of the Constitution being the highest legal norm. But Article 20 of the Constitution has been elaborated further through the various provisions that we have in Land Act 2020 Act 1036, especially starting from Section 237. And Section 237 makes the point that the Lands Commission is to act on behalf of the state in compulsory acquisition of land. So the state agency, which will play the key role in new compulsory acquisition, is the Lands Commission. And Section 237 of Act 1036 makes that point clear. And again, one of you made the point, and it's consistent with Section 238 of the Lands Act, that before you do compulsory acquisition, there must be evidence that money to pay for compensation is available. There should be availability of funds before compulsory acquisition. You don't trigger the exercise of eminent domain, that is compulsory acquisition, where you do not have evidence that you have funds for the payment of what compulsory, for the compensation for those whose property are going to compulsorily acquire. And the other point to notice that now there's a requirement for escrow account, right? That escrow account, that is an account which is set up for the sole purpose of holding money, which will be used for intended purpose, such as payment of the compensation, is supposed to be set up. So if you look at the 238, it makes a point that compulsory acquisition of land shall not be undertaken or facilitated by the Lands Commission unless the intended user of the acquired land proves in writing to the satisfaction of the commission that funds for payment of compensation in other courts associated with acquisition have been paid into an interest yielding escrow account. Yeah, so that is non-negotiable. An intended user, of course, it will certainly be a public body, because compulsory acquisition is usually at the instance of like a public body needing it for certain development. And that is why 2382 make the point that where the intended user is a public body that is fully dependent on the public fund, the public body shall obtain cabinet approval and have an approved budgetary allocation for the payment of compensation and other associated costs before commencement of compulsory acquisition. So if, for example, either roads and highway, or maybe housing, or any government department, just name it, is interested in acquiring, let's say that a certain land, which is a private property and is needed for the public interest, then the government, of course, will need to make budgetary allocation, and money should be actually be deposited in an escrow account, which will be evidence in writing before the process for compulsory acquisition will actually kick in. So this addresses the problem that some of you rightly pointed out, the delay in payment of compensation. Because if you look at the previous regime, compulsory acquisition could take place, and it could take sometimes more than 5-10 years before the compensation reward will be paid. But now, with the requirement that there should be availability of funds in an escrow account before compulsory acquisition will be done, you actually address the problem of the delay. So the escrow account is supposed to be managed by the Lands Commission as a trustee for whoever is going to get the property compulsory acquired for its use. So let us keep that in mind. And then having ensured that we have funds available in an escrow account, which will be used for payment of any compensation, then we must remember that the first step is declaration of the land intended for compulsory acquisition. So there should be a declaration, right? So if you look at section 240 of Act 1036, you notice that there's a particular form which has been designed, under the law Form 1. If you look at the fifth schedule, and it simply requires that the particular land that the state intends to compulsorily acquire for whoever the intended user is supposed to be delineated and published in the Gazette. And published in the Gazette so that everybody will know that this is the land which is intended to be compulsorily acquired. And if we look at section 240, there's an important rule as far as making a declaratory statement in the Gazette that this particular parcel of land is intended to be acquired also carries. And let me just quote that where a declaration has been made, as we have explained, it shall lapse and cease to be of any effect 2 years after expiry of 2 years. So let's say that if you make the declaration in the Gazette, and please, let's keep this in mind, assuming you have a problem-based question, okay? And it is said that maybe 3 years ago, it was published in the Gazette that this particular land was going to be compulsorily acquired and all that. Then you should know, at least 242 of Act 1036 is telling us that if you make a declaration of the intention to acquire the land, and 2 years elapses, you haven't gone ahead. That declaration would actually, if you like, cease to have effect as it will. And all proceedings which are being taken in respect of the land which have been declared will come to an end. Well, what do you mean by that? Let's suppose that you made the declaration in the Gazette about 2 years ago, and as soon as it was made, maybe somebody went to court to say that you cannot actually do this, or you cannot actually go ahead and do the compulsory acquisition, some other things. But then 2 years elapses and you've not gone beyond the mere declaration. Then section 242 says that all proceedings shall actually come to an end. But the exception, if we look at the subsection 3, says that it shall not apply where there's a dispute in respect of the land. So if there has been a declaration in the Gazette that Black Area or Black Acre, this particular land is going to be compulsorily acquired. And let's suppose that somebody is litigating in terms of title or ownership. Then section 243 says that that one will not affect the rule, which says that if you make the declaration and 2 years elapses without you having gone ahead to do the compulsory acquisition, the declaration shall cease to be of any effect. It will not apply to a situation where you have an ongoing dispute regarding maybe title to the land, as the case may be. So let us keep that in. But where the Lands Commission is of the view that it will not be able to carry through with the compulsory acquisition within the 2 years, then if you look at 244, the Lands Commission could go to court for an extension of the period. And then the court can extend the period for 1 more year. So that instead of like the 2 years, now it has like the 3 years within which it should get that done. So let us keep that in mind. And again, part of the procedure for compulsory acquisition is what we call preliminary investigation by the state. And what do you mean by preliminary investigation by the state? If we look at section 241 of Act 1036, it's stipulated that where the state is satisfied that land in any locality is requested for a public purpose, it shall be lawful for a person authorized by the Lands Commission and for the staff, the workman of that person, to do any of the following. 1, enter upon and survey and take levels of the land and adjoining lands in that locality. B, dig through the subsoil for analysis. And you'll be wondering why the subsoil for analysis. So that I want to know the strength of the land for a particular purpose for which it is needed. So that maybe if the state intends to put up maybe like a high-rise building or do some major projects, the engineers will need to convince that this type of land we are going compulsory acquire will be fit for the purpose. And again, 3, undertake evaluation of that land. Get your valuers to do evaluation of that land so that you are certain regarding its value. And then do all other as necessary to ascertain the suitability of the land for the intended public purpose. And also do boundaries. So the preliminary investigations are important. And as soon as the intention is expressed that this particular area will be needed, the law now allows the Lands Commission or people authorized by the Lands Commission to go and do some of these preliminary investigation so that you get the full data, the full information to enable the government to reach a decision as whether the particular property or parcel of land is actually suitable for the purpose, for which reason it will justify the exercise of eminent domain to interfere with someone's private property rights, as it were. So let us keep that in mind. Again, there was a mention of ADL by one of you. So if you look at section 241, subsection 5, there is a provision to the effect that either the Lands Commission or people authorized by the Land Commission to enter the land, which is earmarked provisionally for purposes of compulsory acquisition. Maybe if they go there and then they cause damage, right? Because as they enter the land, maybe they enter the land to go and do the preliminary investigation, they cause damage to the property or the land, they are supposed to pay compensation. Now, the compensation here is not compensation for compulsory acquisition, so let's keep that in mind. The compulsory acquisition has not yet taken place. We are still at the preliminary stage, trying to find out whether the land is suitable for the purpose. But as we try to find out, maybe you interfere, you enter onto the land and your entry may cause some damage, may interfere with some surface rights or other rights of whoever owns the land or occupies it. And you will need to provide compensation. So you've not compulsorily acquired the land, so you are not talking about the compensation which will follow the compulsory acquisition. We are just talking about compensation which may have to be paid due to damage that your entry onto the land as part of the preliminary investigation under section 241 as actually occasion. So let us keep that in mind. And it is in that respect that where the Lands Commission, for example, has made a determination as to how much should be paid as a reasonable compensation, then there could be arbitration under the Alternative Dispute Resolution Act of 2010 at 798. So you don't go to court. The Lands Commission and then the person who is aggrieved could go to arbitration under the ADL Act of 2010. So let us keep that in mind. Now, another important procedural thing to remember under section 242 is that where the state has made a decision to acquire land compulsorily along the lines that we are discussing, then the state is obligated to officially notify persons who have got interest in the land. And this is very important because of issues of compensation. We don't want a situation where you do the compulsory acquisition and after many years, somebody will come and say that that land belonged to our family or my uncle and no compensation has been provided. And that is why now, to avoid all such confusion, the law is that you should actually officially notify those who have interest in the land, which the state has decided to compulsorily acquire. And the state is even supposed to make like reasonable inquiry to find out. So making a publication in newspapers and all that to let people know that it intends to take this particular land. So let us take note of that. So the notice, of course, shall be published in the Gazette so that everyone will know. And if the state also know the persons whose interests are affected by its decision to compulsory acquire, the state shall cause the notice to be served personally or at the usual place where such a person can be reached, so that he or she will be in the know regarding the fact that the state intends to compulsory acquire. And the same thing applies also to artificial persons like corporations or company. Don't forget that property to compulsory acquire may also belong to a company. Maybe a company may have particular property, and then that property is needed for the public purpose. And that also becomes a candidate for compulsory acquisition. So for that matter, if you look at section 242, it's not only the natural person, but if you have artificial persons like the corporations or company, you must also notify them that the state intends to compulsorily acquire this particular land that they have interest in. So let us keep that in mind. And apart from the Gazette notification, there should also be publication in the newspaper circulating in the particular district, as well as a national newspaper, so that those who have got interest will know about it. Now, if we look at section 242, subsection 6, it makes the point that where the notice has been served, that is the notice that the state has decided to compulsorily acquire the land has been served. Now that notice shall lapse, that is, it shall cease to be of no effect if no action is taken as a result of that notice within 1 year from the date of the publication. In other words, if notice is served on you that the state has decided to acquire this particular land, in respect of which you have interest, and it is served on you or it is published, but nothing is done. If 1 year elapses and the state has not done anything, the notice will have no effect. And what it means is that you go back to the old situation, nothing has happened. The only exception being that it is possible for fresh notification to be served by the Lands Commission. If the Lands Commission is satisfied that the land is actually needed for or is likely to be needed for public purpose. So that exception is there, that yes, 1 year has elapsed, but if subsequently the Lands Commission is convinced that the land will be needed for public purpose, it can serve a fresh notification on the person whose interest is likely to be affected by the decision of the state to compulsorily acquire that land. Now, another important thing is about the consultation with stakeholders. Where a decision has been made to compulsorily acquire a particular parcel of land, Section 244 requires that there must be consultation with stakeholders. There must be consultation with the stakeholders. So stakeholders are those whose interests are likely to be affected, as well as occupiers of the land, traditional authorities, and community leaders, and all those who are in one way or the other have got some interest in the particular land, which is likely to be compulsorily acquired. There must be engagement, some conversation, some consultation with them. And the law requires that the regulation should be passed in the form of LI, which will regulate how consultation may be held with stakeholders whose interests are to be affected by intended compulsory acquisition. Now, the Lands Commission is also obligated by Section 245 to prepare and publish a report of consultation. So there must be a published report that a consultation has actually been held with stakeholders of proposed acquisition. And that is very important. And the report is supposed to be, if you like, made public or available to anyone who is interested, so that you can go to the district assembly or you can go to the particular traditional authority who will be giving copies of the report of the consultation held between the Lands Commission and those whose interests are likely to be affected by intended compulsory acquisition. So let us keep that in mind. Now, it is possible for the states to have a change of mind or lose interest and withdraw from intended acquisition. So if you look at Section 247 of the Land Act, 2020 Act 1036, there is a provision in Section 247 to the effect that the states may withdraw from an intended compulsory acquisition of land by publishing a notice of the withdrawal in the same manner as in Section 242. So if at any point in time, the state, for example, loses interest or has a change of mind, or maybe as the stakeholder consultation is held, the state gets to know that the stakeholders, for example, are becoming more and more unreasonable in their demands or expectation or things like that, vis-a-vis maybe the purpose for which the particular land is needed. The state can actually pull out. But where the state decides to pull out, it is required to also publish a notice in the same way that it published a notice that it intended to acquire that land. So let us keep that in mind. But where the state has decided to make a withdrawal in terms of abandoning the intended compulsory acquisition, the Land Commission is required to have consultation with persons affected by the withdrawal and determine amount of costs and damages incurred by the affected person. Why do you say that? Don't forget that we talk about preliminary investigation. So preliminary investigation might have, for example, affected some of the stakeholders. And then let's suppose that there's an ongoing stakeholder consultation and all the losses or damages and other complaints they have are going to be taken care of in the final agreement, which will be made. But in the middle of it or midstream, the state withdraws. So if the state is not going to go ahead with the compulsory acquisition, the stakeholders might have also suffered some losses. They will have to be compensated. So here, they're not being compensated for compulsory acquisition. They are being compensated for certain things that they have incurred as a result of the intended compulsory acquisition, which has now been abandoned by the state, as it were. Again, because money for compensation is supposed to have been lodged in the escrow account, where there's a withdrawal by the state, that the state does not want to go ahead with the compulsory acquisition, the Lands Commission can actually go into the escrow account and then pay the incidental expenses or costs to the stakeholders following withdrawal by the state from the earlier advertised compulsory acquisition. So let us keep that in mind. And in trying to actually determine amount of compensation which should be paid, the Lands Commission is supposed to be guided by a lot of things, especially what we call there's this legislation, which I'm sure you are aware from your land law, but if you are not aware, we are mentioning it. There's this legislation we call the Land Use and Spatial Planning Act, 2016, Act 925. Land Use and Spatial Planning Act, 2016, Act 925. What it seeks to do is to actually provide a legal regime in terms of zoning, in terms of approved user of various areas. Or if you want a particular zone, maybe previously it meant to be for light industrial zone, you want to be used for, let's say, residential or something, then there's a procedure you have to go through. And all those things are made possible by this particular legislation, Land Use and Spatial Planning Act 2016, Act 925. So when the Lands Commission is trying to determine the appropriate level of compensation, which should be paid in circumstances as we have indicated regarding the compulsory acquisition or the withdrawal by the state of the compulsory acquisition, it will have to have regard to the particular permitted use for that area under this legislation, as well as the environmental condition for that particular area, or what the local planning authority have actually designated that place for. So the Lands Commission will be guided by all that in determining the compensation. But a very important procedure to remember with respect to this compensation, this compulsory acquisition process is what we remember from Article 20 of the Constitution, that is the publication of the executive instrument, as it were. So if you look at Section 249 of Act 1036, there is a provision to the effect that acquisition, that is compulsory acquisition that we mean, acquisition takes effect from the date of publication of the executive instrument which we have already alluded to. If you remember, we have talked about executive instrument and section 233. So if you go to section 233, we are told that the states may compulsorily acquire any land if it's considered necessary, just like re-enactment of Article 20 of the Constitution. Article 20 of the Constitution. And that is why when we're trying to answer the question, if you remember, I told you that I am not comfortable with you just limiting yourself to section 239 to 249, because we are talking about compulsory acquisition. It is better to even look at the whole of chapter 7 of Act 1036. When you go to Act 10, chapter 7, the chapter heading is acquisition of land by the state. And if you look at section 233, section 233 essentially reenact Article 20 of the Constitution by giving more flesh. So if you want to get the full picture on compulsory acquisition, it's better to start from section 233. And as I said, over there, you will notice that it is essentially reenacting Article 20 of the Constitution, so to speak. And that is why section 233(1), among other things, will say that the states may compulsorily acquire any land where the acquisition of that land is necessary, A, for public purpose and in the interest of defense, public safety, public order, public morality, public health, town and country planning, resettlement purposes, or for the running of essential services. B, for road, highway, railway, pipeline, a canal, dam, sewage system, or any public utility service. Or C, in order to secure the development or utilization of that land or other land in a manner that promotes the public benefits, unquote. So here, you notice that it's essentially reenacting aspects of what? Article 20. And that is a compulsory acquisition. Now, the necessity for compulsorily acquiring that land is required to be stated in the executive instrument, which is supposed to be published in the Gazette. And if you remember, Article 20 of the Constitution is just like a similar idea, which is there. So the compulsory acquisition takes place from the date that the executive instrument was published. But if you look at the sequence of things, the executive instrument is going to take some time before it will be published, because among other things, you need to do the preliminary investigation to become certain regarding the suitability of the land and so on for the stated public purpose and all that. And of course, you also make sure that you have enough funds in the escrow account that we've talked about and all that. So all these things you go through before the executive instrument is actually published. So section 249 of Act 1036 should be read together with section 233. So when you are reading section 233, go to section 249 and read it as well. Or if you are reading section 249, go back to section 233 and read the two provisions together, so that you get like the full picture. Because the two provisions contain the actual instrument by which you effectuate the compulsory acquisition, where you state the particular property to be compulsory acquired, the purpose for which it is being acquired, then the compensation which is supposed to be paid, and so on and so forth. All those things reflected in that particular instrument. So let us keep that in mind. And let us remember that there are some strict rules regarding the adherence to these procedures on compulsory acquisition. And that is why you look at section 249, subsection 4 and 5 contain some strict rules that on publication of the executive instrument, the land shall without further assurance vest in the president, free from any encumbrance. So once the executive instrument has been published under section 249, read with section 233, the land immediately will be released from all encumbrances, and it will vest in the president as it were. Now, the 5 makes the point that if you do not follow all the procedures that you talk about in publishing the executive instrument, which is seeking to effectuate the compulsory acquisition, then any purported acquisition shall be of no effect. It shall be null and void. So these are important procedural safeguards which must be followed to have a compulsory acquisition as it were. So let us keep these things in mind. Now, if you remember this, I think that it should be good as far as compulsory acquisition is concerned. So we will leave this, and then we'll pick 1 or 2 questions that you may want us to add to it. I have to go for another event now. Yes, so I will take few questions and then we'll wind up. Yes. Let me see, somebody, somebody put a question. The sector doing the acquisition must have the money readily available in the escrow account before such acquisition to do away with the. Yeah, so it's not a question, it's a statement. Okay, yes. Jack and Elizabeth, go ahead.
Good evening, Doctor.
Okay, sorry.
Oh yeah, Jack. After Jack, then Elizabeth. Okay.
Doc, good evening.
Good evening.
Thank you for the opportunity. Doc, what about if you have a conflicting interest in the land, how will the state deal with that interest?
If you have a conflicting
interest, like those 2 people fighting over the land.
Okay, so A is saying that he is entitled to get a compensation.
Yes.
And B is saying that it is rather he. Is that situation?
Yes, please.
Okay, so if you go to section, there's a direct provision which provides answer on the conflicting claims. Let me just a minute. Good. Yeah, conflicting claims of interest, section 254. So if we look at section 254 of the Land Act 2020, Act 1036, it provides how conflicting claims of interest and rights should be managed. So, for example, section 254 will remind us that where there is a dispute as to the right or interest in the land claimed, the claimants, that is A or B or C, each of them saying that I am lawfully entitled to this land, and for that matter, whatever issues there are with compensation for the Lands Commission, I should be pursuing that. Now, where you have that situation, then section 254 says that the Lands Commission must refer the resolution to ADR you try and do some either mediation or arbitration, as the case may be, in order to resolve who is rightfully entitled to the land, which is the subject matter of compulsory acquisition. Now, it does not mean that you cannot go to the High Court, because if you look at Article 20 of the Constitution, there's a provision that where you have such conflicting claims and all that, you can go to the High Court. Now that is there, and that is why Section 254, subsection 2 says that the fact that the Lands Commission may refer the conflicting claims to ADL does not mean that the right of the claimant to resort to the High Court, as guaranteed by the Article 20 of the Constitution, have been taken away. No. So all that it means is that now you have the option. The Lands Commission will refer you to ADL, but you can still also go to court. But the good thing is that now if you go to court, the court has also adopted what they call the court-connected ADL. So if you decided to ignore the Lands Commission referral to ADL and you went to court, when you go to court, the court will also refer you back to ADL at some stage of the proceedings. So that reinforces the point that ADL has become very important in managing some of these conflicting claims. Yeah, any other? Yes, Elizabeth, I think your hand was up before Jack.
Okay, Doc, please, good evening.
Good evening.
So when you read section 233, it says that the reason for which the acquisition is being made should be stated. So assuming it was being acquired for a hospital, right, and now they are building hostels or bungalows for the doctors or something which is incidental to the hospital, will this still nullify the acquisition, or it will still be deemed valid?
Oh, okay, so that's where you go back to the Okujeto Ablako and then the late minister's case, if you remember, about the airport residential land. Yeah, so going by that case law, the argument will be that so long as it is being used for another public purpose, even if it's not being used for the original stated public purpose, but it's being used for another public purpose, then according to the Ablaka authority, it is still permissible. But there's a provision in the new act, especially if we look at the section 2C7, okay? Let's look at 2C7, for example, and let's see if we get some direct response, quite apart from what the Supreme Court said. Where land has been compulsorily acquired under this act, or before the coming to force of this act, a subsequent disposal or use of or dealing with the land, whether by the state or the person on whose behalf the land was acquired, shall not invalidate acquisition of the land, except that the disposal or use of or dealing with the land shall be in accordance with provisions of Article 20 of the Constitution. Yeah, of course, this is speaking to situation. Yeah, of course, yes, yeah. So where there has, so long as you have safeguarded the interests of those, though if you look at, let's say, Article 20, right, of the Constitution, it says that if you are releasing the land, you give a first option to the original people. So let's look at Article 20 clause. Let's look at Article 20 clause. Good. 6, for example. If we look at Article 20, let's look at the clause 5 and 6. Article 20, clause 5 and 6 of the Constitution. So 5, any property compulsorily taken possession of or acquired in the public interest or for a public purpose shall be used only in the public interest or for the public purpose for which it was acquired. So this is where it said that in the public interest or for the public purpose. Okay, so let's look at the 6. Where the property is not used in the public interest or for the public purpose for which it was acquired, the owner of the property, immediately before the compulsory acquisition, shall be given the first option for acquiring the property and shall, on such reacquisition, refund the whole or part of the compensation paid to him as provided for by law, or such other amount as is commensurate with the value of the property at the time of the reacquisition. Unquote. Yeah, so 2 things. So first and foremost, the land is acquired for, as we said, let's say that it was going to be used for building a public hospital, let's say a teaching hospital. Now let's suppose that that was not done. And later on, they decide to use it to build a school. That's still fall within the public interest. It falls within the public purpose. Because if you look at the, the definition of what is the public interest, the public purpose, anything which inures to the benefit of either the whole of Ghana or section of Ghana, so that will suffice for the public interest, the public purpose. And for yes, thank you. Somebody has put the top block against the which yes, thank you for putting the case there. Good. Yeah, so that will still suffice. But in order to guard against what we call unjust enrichment, okay? So the principle of unjust enrichment is embedded in Article 20, clause 6 of the Constitution, as well as the land act, that if the land was compulsorily acquired and it is not used for the purpose for which it was acquired, and the state would like to dispose of it, the original owner should be given the first option, meaning that it should be returned to the original owner. But the original owner took compensation. You cannot get the land back or the property back and still hold on to the compensation that you were given. You either return the compensation either in full or in proportion to the current value of the property. Previously compulsory acquired, now going to be restored to you. So that way, you guard against unjust enrichment, because you cannot have your cake and eat it back. Yeah, so Elizabeth, that is the situation. Until we don't have anybody. Okay. Any otherwise? Somebody, you want to say something?
No, sir.
Right. Okay. All right then. Have a very good night.